Okay, who do I? You can take your hands out of your pockets.
Oh, I don't know.
Okay. Who do I have here?
Rico Crawford.
Why'd you interrupt?
Cause
That's what he does, right? He does that all the time, right? He won't let you speak,
he gonna let me speak today because he ain't got that.
right? Okay. That's the way it's gonna have to be today. All right, go ahead, Council Wood.
Yes, Judge, the parties have a consent judgment for possession only, rent to retain is $6,371. Attorney fees and costs in the amount of $170 for a total of $6,541 due and owing by 5/29/2026. No money judgment is entered. We did discuss the 3-day rescission rule as well as the 10-day appeal date.
Ma'am, is all of that correct?
Yes.
Yes. Okay, I have to talk to you. So yeah, is that right?
Yeah.
Okay. All right. You guys gonna be able to get this done by this time?
We're gonna try. Well, we got 1,500 today, so we're gonna turn that in.
Okay.
I'm gonna try to get the rest by the 22nd. Well, I didn't talk. I didn't
What?
get the rest. I have appointment with Hawk on the 13th, but that was before the May rent came in, so I don't know. I got to get it down to 3,000.
So you have an appointment?
Yes.
Why don't I know that?
Right.
Sorry. Sorry, this is landed great. Could have been uglier. You on May 13th, you have an appointment.
Yes, at 11 o'clock.
Did they give you? This is why I need a real person. Did they give you any indication whatsoever as to what they thought would happen? Because they did a pre-screening with you. So
Yes, they did. Well, that was before, like I said, the May was in there. So she did tell me I had 1,500, and then I also have another organization, Friends Indeed. They're supposed to give me like 600, but I'm going to try to ask them for more because now that this balance is here, and then I was going to have additional 500 by next Tuesday. So then that would have worked because it would have been kind of close to the 3,000. And she said, would have been able to have it, but oh,
okay.
Yes.
So let me ask you this. Let's say you get this down to where you go 3,000. And Hawk says they're out of money or won't pay. What are you guys gonna do?
Yeah, honestly.
Pardon?
Yeah, because I'm in college, so
Yeah, I mean,
You're what?
I'm in college.
I'm really
That's
hoping.
my mom.
Yes.
No, that's why you gotta be more respectful.
He really is.
I know. But he said that he ain't saying a word.
That's what I'm praying for. I mean, I don't know. I'm hoping that, they could have helped, but I understand there's a lot going on. And like you say, it's changing, but
Okay. Where are you in school, young man?
But we're at Washington Community College.
And what are you trying to be when you grow up?
Business and management. That's what I'm majoring in, but I'm thinking about changing it.
Okay. And then after you get finished at Washington, where are you going?
Michigan State. This would be my last.
Oh, see,
I'm
it was okay until you said
Michigan State. Okay. This would be my last.
I was with you until all of a sudden that came up.
that's as well.
All right. Maybe it's just you trying to get him through school and everything.
I'm trying. Yeah, it's just me. I got 2 other kids too. So,
All right.
yeah, it's
Here's what I'm gonna do, and I'm flying by the seat of my pants in part on some of this, but I'm trying to look at these folks as just real people trying to do what real people do. And here's mom trying to make sure her son gets through school. Um, and Alan, make a note of this, that I did this for somebody who said they were going to be a Spartan.
Uh-oh.
Okay. I'm going to just add some language that if the defendants pay the 3541 and then Hawk says no to the 3,000, then there'll be a hearing before a writ will issue. All right. You follow me? Because I don't, as I understood it from the meeting I had, I don't know that they're going to have the money. But it sounds like what they've said to you at least leads you to believe that they are.
Yeah.
So I'm not going to let anything happen without at least a shot at something else if we have to do it. Fair enough?
Thank you.
Thank you so much.
All right. You guys take care, okay?
Thank
you so
you.
much.
All right.
And-
You're welcome. Should think about a real school like Maryland.
Okay.
All right. Now I'm just saying, you do what you got to do, but is that it for your counsel? Thank you so very much. State your name.
Fatima Musa.
All right. What are we doing on this case?
Your Honor, I believe that Ms. Musa and Mr. Ibrahim have filed amended or new pleadings. My understanding is that what was previously filed was struck by the court as it didn't comply with the court rule. I'm not entirely convinced that what was refiled complies with the court rule. There have been some changes to it, but there are still several sections of the pleadings that still don't comply with the applicable court rules. I would argue, I suggest that these pleadings were AI generated and not appropriately revised to comply with the Michigan court rules. And so I would argue that they should be struck yet again. But I would defer to the court in that regard.
What do you have to say to that?
Your Honor, 90% of those pleadings is exhibits.
Pardon?
Exhibits. 90% of it is just documents.
Yeah, but it's got to be presented in the proper fashion,
Right.
and they're not.
The answer to non-payment of rent. That's correctly.
How much is owing?
Your Honor, this isn't an action for non-payment of rent. This is an action for termination of tenancy. A 30-day notice to quit was issued as defendant. Ms. Musa is a month-to-month tenant.
And we've been month to month since the beginning, or at least
All right, but what's your defense to the termination?
the, we had a housing inspection on Monday, actually, because of a mold issue from February that we asked them to fix properly.
So
Uh,
let's assume all of that's correct. Why should you be permitted to stay in the premises?
Well, the city came to us and told us that this unit doesn't have a valid certificate of occupancy. We don't actually want to.
Okay, if it doesn't have a valid, you're going to leave then? When you going?
Exactly. I don't plan on
When are you going?
by the end of the month.
By when?
Month.
This is a case for possession only. They don't want you there. You say you're leaving. So
Well, yeah, we have no problem with the possession case. It's more of a, I paid $45,000 in rent over 3 years. And first of all, the lease don't have a valid certificate. And the unit has been moldy the entire
try to
time.
get your pleadings in order on that, because that's not really properly raised before the court.
What was the issue with the answer to non-rent?
Have you gotten a lawyer on this? Because I'm not here to give legal advice.
No, we're not. We don't have a lawyer on this.
So they did not Did you pay to sue them for a money judgment?
Say again? Did I pay them?
Yeah, you're trying to sue for a money judgment.
Did I pay the court, you're saying?
Yeah.
No, they told me there's no fee for that to file the papers.
And
All right.
Your Honor, if I may just add for the,
Go ahead.
just to be specific with respect to the issues that I have with the pleadings, Your Honor, there's two different answers filed. One is an answer to a non-payment of rent case, which doesn't apply here. The second is an answer civil, which would apply for a general civil case. This isn't a general civil case, summary proceedings case. So there is no proper answer filed. There's a
That's-
document filed called an order for change of venue, which appears to be a request to transfer the case to the Washington County Circuit Court, but that's not a venue issue. That's would be
Correct.
removal request based on allegations that, based off of this, I believe his allegations are that his alleged damages exceed the jurisdictional limit of the district court.
But I don't have an affidavit on the claims.
And Your Honor, there is a document filed that's called affidavit in support of petition of change of venue. The problem with this alleged affidavit, and in reality, Your Honor, it is a regurgitation of the alleged counterclaim, number one.
Right.
But number two, it's not an affidavit because it's not been signed in the presence of a notary. So it doesn't constitute an affidavit. And so this so-called order for change of venue doesn't apply either. With respect to the counterclaim, again, Your Honor, as was indicated at the last court date, even though some changes have been made, the bulk of this counterclaim still does not comply with the applicable court rules. And so for those reasons, I'd ask that the court again strike all of these documents as improper. Again, I would also, as the court indicated, this is an action for possession. Defendants are, well, defendant Ms. Musa and Mr. Ibrahim, who I believe is an unauthorized occupant in the unit, are in agreement with vacating. And so I don't have any authority to grant additional time beyond the 10-day time frame. So I would have to ask for a judgment requiring possession on or before May 18th. But again, I would defer to the court with respect to that.
But why would you say that I'm not an authorized occupant of the unit when I've been paying you guys since the beginning of the lease? I have emails with the management, or the property manager, everyone that works there, addressing me by name. I pay you. My mom has never paid anything to Spice Street Apartments. Why would you say I'm an unauthorized occupant?
Well, it really doesn't matter whether you're an unauthorized occupant or not, quite frankly, because the pleadings and documents that are filed are not in order. They're not in compliance with the court rule. There isn't even an issue regarding venue in this case. That's not the terminology that would be used. To the extent I were to even construe it as a motion for removal, doesn't have a proper affidavit attached. It doesn't have an affidavit, as far as I'm concerned, attached to it, so it's not filed in compliance with the court rule. I'm going to order once again that the documents are stricken as they are not filed in compliance with the Michigan court rules. I am then finding also that, given the statements of the defendants, that there's no tribal issue on a termination case in this matter. I'm going to grant a judgment for possession to the plaintiff for possession. There's no redemption amount. A writ would issue in 10 days.
No. Carla?
Pardon?
2 weeks?
Pardon?
2 weeks on the writ?
18th?
And it's
You'll have to deal with the landlord if you want additional time, but it's 18.
and I have no problem giving the property back. If they're not going to fix it, I don't want to live in a moldy unit. Is there no issue, even if with all the documents being struck, is there no issue with them renting me a property that is not compliant with the city?
There may be an issue,
Right.
but you have to file the proper paper. I'm not going to make your claim here. You have to do it properly.
Okay.
So if you don't know how to do it, get a lawyer.
Give us time to do that. We got this summer.
Sir, you filed the additional pleadings. I had to strike them.
Okay.
Then you redid it. I had to strike them again. I'm not going to waste my time waiting for you to get it right.
I'm asking for time.
If you wish this court to do something else, get a lawyer. They can file a motion with this court to do something else. But at this point, I am not. The judgment that I've issued just now will stand. Thank you.
And Your Honor, I would just also point out that to the extent that they feel they have a claim against my client, it does not have to be brought in conjunction with this case. I would disagree that they have a claim, but that doesn't change the possession issue. So.
That's right.
So
Yes, ma'am.
can I ask a question? Can I move my name? Because this is
She doesn't live here.
this is his problem. I live somewhere else.
You live someplace else.
Yeah.
I know, and that's what we were told. The problem is you're still on the lease. I can't remove your name. Thank you.
What made this courtroom moment so intense wasn't just the eviction dispute. It was the judge's growing frustration over filings that repeatedly failed to meet basic court rules. The court made it clear that even if someone believes they have a legitimate complaint, the legal system still requires those claims to be filed properly and supported the right way. That's where this hearing completely fell apart. In simple terms, the judge wasn't saying the defendants had no concerns. He was saying the court cannot move forward when procedures aren't followed correctly. But here's the bigger question. As more people start relying on AI-generated legal documents, are courtrooms about to see even more situations like this?